I just want to get a clarification to understand your situation at the time. Is it correct that you were not a prosecutor? You were in a separate office within the Justice Department, is that correct?
That's correct. I was in an independent office within the Department of Justice. I was not on the prosecution team. We gave ethics advice prospectively to attorneys who were involved in cases to try to keep them out of trouble, to try to keep them from getting in trouble later on. You don't want them to be sanctioned or disciplined by the judge or get in ethics trouble later. And even if they do mess up, we would still help them try to figure out how to correct that by sealing off an interview or creating a taint team to look at information that we got the wrong way and that kind of thing. So no, I was an ethics attorney, the legal advisor who happened to be called on that morning, Friday.
When you took the job, is it because that you felt that the federal prosecution of federal crimes was a particularly important thing, and if so, has your view of that changed from this experience?
Yeah, when I originally went to work for the Justice Department, like I said, I was very much the government wears a white hat and does the right thing and is on the right side, and naive about that. When I switched to the ethics office, that was really because I had done constitutional tort litigation for 4 years, and at that point I had 2 small babies, and litigating was incompatible with flying all over the country and crazy deadlines and litigation, and I liked the ethics stuff. It was very interesting to me, and they were opening this new ethics office, and I thought that would be a good match, and I felt like for the first couple of years it was a good match. I didn't feel a huge change between Reno Justice Department and the Ashcroft Justice Department. I mean, granted, Reno was much more, she was very open, very kind of glass-nosed, let's hold hands, sing kumbaya. Yeah, she was a lot more open, and Ashcroft liked a very top-down corporate structure. But for me, the real sea change at the department was after 9/11, when everything, I think, went out the window. And it was, I mean, we heard the language all the time. We're in a new kind of era. It's a new kind of war. We need new techniques. We need new this and new that. And yeah, maybe we have to do some things differently, but we have a way of doing that by going to Congress and fixing the law, and not by doing it in secret, not by enacting the Patriot Act, which no one read. Which was essentially a Christmas tree of, a lot of people, a wish list of a small minority of people who wanted the kind of government that we have right now today. Jake.
Jesselyn, would you talk a little bit about the gag order that was placed on Lindh as part of the plea bargain, which seemed to be kind of an unusual thing?
Yeah, it would seem to be an unusual thing, but the gag orders that have accompanied not only Lindh's case, first of all, what does it say? It basically says he's prohibited from talking about this. Not only, I mean, often there may be something saying that a defendant is prohibited from profiting from what they've done by writing a book or selling the movie rights or something like that. But no, this is, he is prohibited from talking about it ever with anyone, with his eventual wife if he were to get married. And it doesn't matter that me and you and God knows who can talk about it over the internet. He specifically is not allowed to talk about it ever. And the use of gag orders in these plea bargains has just seen an astronomical increase, just like the use of the state secrets privilege, which was invoked maybe 25 times during the 20th century and has been invoked more than 38 times in the last 8 years. So right now, the gag orders, a lot of people are gagged from talking about certain things. There are certain things I cannot talk to you about, and I can't say anything more than that. Sibel Edmonds is gagged. There are a lot of people who are gagged even when there's been no conviction, because something that is in our brain happens to touch on something that someone deems to be national security. So it puts people in a very odd position. I'm like, how come the whole world gets to say the T word, but I don't get to? And it's a strange universe. But the gag order that was placed on Lindh has been used in a lot of other terrorism plea bargains.
Yes, I was wondering, I have two quick questions. One, do you think there will be some First Amendment free speech challenges to these gag orders going to be coming up? And the second one is, were you in the office, the ethics office, when Reno was in the Clinton administration, when the Waco incident at all took place?
No, I was not. I was doing constitutional tort litigation when the Waco thing, it had happened right when I joined. And then we had Waco and Ruby Ridge and a number of debacles. They didn't have the ethics office at that point. The ethics office was actually, people confuse it all the time with the Office of Professional Responsibility. They're the back end of the ethics. They will discipline you after the fact once you've screwed up. This new office was created in 1999 with a very similar name called the Professional Responsibility Advisory Office, and it was created basically because of the McDade Amendment, which Joe McDade had sponsored because of his experience of government overreaching. And the McDade Amendment said that prosecutors had to abide by not only their own state bar ethics rules, but the ethics rules of any state in which they litigated. So for a number of prosecutors who barely knew their own ethics rules, suddenly they had to know the ethics rules of whatever state they happened to be in. And so we were there to help them figure that out and try to help keep them out of trouble. So yeah, that office didn't even get created until 1999, and I think its utility quickly, I think it's just a dead letter office right now. I mean, it still exists, but the First Amendment challenges, here's what's happening with that. There have been a number of First Amendment challenges to both the gag orders. Sibel had a First Amendment challenge, Sibel Edmonds, who had been an FBI translator. She had a First Amendment challenge. It went all the way up to the Supreme Court. The government blocked it all at every stage by asserting the state secrets privilege. We can't litigate this because it's going to reveal a state secret. The other challenges that involve First Amendment or Fourth Amendment also, like the warrantless wiretapping, again, those have been blocked completely by the government asserting the state secrets privilege. Again, there isn't really a state secrets privilege in the United States. This is just something that's kind of been out there and brought up here and there, but it hasn't actually, I mean, there isn't really such a privilege. It's been brought up here and there in some very high-profile, super secret cases, but the government's just asserting it left and right. So when you do hear the First Amendment challenges and the Fourth Amendment challenges to what's going on, they say state secrets privilege, and they usually slap a gag order on you too. And then if you try to challenge the gag order, again, we can't allow a challenge. It'll violate the state secrets privilege. She wants to talk about something that touches on national security. Granted, everyone in the world is talking about what Sibel exposed, but she herself, she can talk about it up to a certain point, and we all have a team of lawyers that we consult with about, okay, what can I say about this? What can I write about this? But